sometimes, defendant lawyers in law firms. I apologize, Your Honor.
No problem.
And I also want to point on the procedural question. Back on March 2nd of this year, this court entered an order of consolidation. I guess we should call it partial consolidation. I think that's the word that was used. Of this case, the Garner case, with the Cartwright case, the case that was just ordered. And so on that basis, I would specifically ask this court to consider the arguments that I made in the first case, Cartwright case, in this argument as well. I think that's probably efficient. Now, as in the Cartwright case, we submit that this court has the authority to reverse the trial court's holding that the TPPA doesn't apply, and then evaluate the plaintiff's response to the motion under the TPP, and then dismiss the complaint. Now, we think that's particularly true here, where the Garner's claim flies just so directly in the face of the American rule on fees and the litigation privilege. That said, I want to focus my argument on the trial court's actual error. So this lawsuit is about the fact that to get around the deeply entrenched American rule on fees, the Garners sued on this novel theory of tort of another. And after all, they're not clients. They can't sue for malpractice, right? And remember, this case involves the parties on one side of litigation suing the other side's lawyers, all right? And they won the litigation that's now over, except for their still pending Rule 11 sanctions motions. Now, what are they suing for? Well, what they're suing for is that they claim my clients brought for their client, Alan Cartwright, allegedly frivolous and meritless litigation, and that the Garners incurred fees and expenses in defending them. The court says that. There's just no question about this, that that's what this case is about. They have epic statute of limitations problems. I'll be surprised if Mr. Wade does not begin his narration of the history of this dating back, as he should, and he always does, to 2004. So that was why we filed a dispositive motion. In the face of that dispositive motion, they tuned up and changed their complaint. That's the claim on which the Garners wish to proceed, and so my clients filed a TPPA petition. Now, fundamentally, the trial court committed the same error here as in Cartwright. And the trial court found, as a general rule, based not on any reading of the Tennessee statute, but those of other states, that anti-SLAPP laws don't apply to lawsuits like the Garners here, okay? But the trial court, again, relied on this California law we've talked about already that includes the language in furtherance of that person's right of petition. That's simply not in our law. And further, the court reformulated the language a little bit. And again, as I said before, they also considered whether my clients were acting in the best interest of their clients. Again, language lifted from case law there, built on that language in California. Again, there's nothing in the TPPA to support this. Now, the Garners can't dispute, I don't think they do, that this lawsuit, or excuse me, that their lawsuit was filed in response to. Filed in response to, that language is part of the trigger for the TPPA. And so the only meaningful question here is whether, in fact, my client's conduct was the exercise of the right to petition, as that phrase is used in the TPPA. And I would restate the same argument you've heard before in Cartwright, but to be clear, the same conduct by my clients is at issue. The same conduct. And the TPPA has got to be construed consistently in these two cases. We submit that the court has to interpret that phrase, exercise of the right to petition, to cover my client's conduct in both appeals, unless, one, the court's willing to engraft an exception on the TPPA's clear language, and then second, also willing to find some nuance in that exception that distinguishes between claims brought by clients and non-clients. We think both those approaches would be wrong. We don't know anything, any language in the TPPA to support that. For example, there's no language in the TPP at all that talks about what the identity of the claimant is. The only discussion in the TPPA that talks about the nature of the claim is the rights, the constitutional rights that are implicated by the conduct. It's not about, it says nothing about, is it a fraud claim, is it a malpractice claim, nothing. Now, the Garners also argue that my clients were required by the TPPA to establish that they were a party to the prior litigation. Now, that's manifestly not what the law says. In part, the simplest way to understand it is that A TPPA petition can be filed in response to a lawsuit that has nothing to do with conduct in litigation. So if Mr. Wade were right about that, that would gut the TPPA. It would be just essentially gone. Think of the cases this court alone has handled that wouldn't exist. So another particularly pernicious aspect of Mr. Wade's argument, the Garner's claims really, unlike Cartwright, is implicit in this distinction they make between the right of a lawyer, the right to petition of a lawyer, and the right to petition of a lawyer's client. It would be interesting to ask the Garners whether, had they sued Mr. Cartwright on the same conduct, the TPPA would apply. After all, someone's rights were being asserted, right, against the Garners in the underlying litigation, somebody's. But the Garner's argument that my clients have no right to petition on their own appears to suggest that while the TPPA would be available to protect Mr. Cartwright, it wouldn't be available to protect his lawyers. Now, again, I've said this before, to put it politely, there's nothing in the statute to support that kind of distinction. I also want to get back to something I talked to earlier, and this is, as I mentioned, the Garner's brief is replete with this. You don't have to get past the third line of their brief where they say that the fundamental question of the appeal is whether my clients, quote, can avoid liability for legal malpractice, misrepresentation, concealment, and other related torts by relying on the TPPA. That they repeatedly use this formulation to suggest that somehow the TPPA protects or insulates my clients from liability. Members of the court, that's just false. We contend it's the law of Tennessee, the substantive law of Tennessee, which is both Mr. Duncan and I have read to the court in 108, is very clear that it doesn't affect the substantive liability. And so our position is, and it's the second part of the analysis under the TPPA, that tort of another doesn't cut it as a matter of law here, and that bringing a claim on for tort of another where the targeted conduct is our right to petition, whether it's our right to petition on our own or our right to petition for our clients, that falls within the TPPA. And so it's just wrong to suggest that the TPPA, that we are using the TPPA or it is available to be used as a way to somehow avoid liability. And by the way, the TPPA talks the same way. It's clearly procedural because it addresses both. It says in 108, it doesn't affect the substantive rights of parties. It doesn't affect their defenses, claims, liabilities, all that. So that said, we strongly believe that Tennessee law does protect my clients from liability, and we want to use the TPPA as intended to expedite a ruling on the law dismissing those claims. Now, in a similar vein, the Garners really deeply confuse the TPPA for some sort of new body of substantive law when they argue that my clients have no right to rely on the TPPA because, quote, there's no constitutional right to file frivolous lawsuits. Now, it's a fascinating legal question, okay? Members of this court probably know some of the stuff I do for a living, and that includes legal ethics and media law, so I particularly find that fascinating. We devoted a whole footnote to this. Frankly, I think they're wrong. I doubt that their statement about that is true, but it doesn't matter. It is completely academic. It is probably of interest to me and nobody else, whether that is true or not. It's academic. It's academic because their argument, if true, presumes more than the TPPA requires, and to accept it, and this goes to Judge Stafford's first question, it seems to me, to accept it, that presumption would dramatically rewrite the TPPA and neuter it. Nothing in the TPPA requires that in order to be able to use it, a party defendant has to prove that they were in fact legitimately, conclusively engaged in constitutionally protected conduct. We are at a stage that is very much like a motion to dismiss. So the notion that the defendant, to invoke the TPPA, has to put on some proof, not only that facially it appears to be a right to petition that was involved, but, oh, well, yes, under all these cases, this right to petition was perfectly legitimate. That's not what the TPPA requires. That very determination would be made in the substance, the substantive trial of a lawsuit. What the TPPA says is that the party defendant is entitled to have plaintiffs show that they can make out a prima facie case before extensive litigation and discovery is imposed on it. That expedited demonstration of a prima facie case is the point of the TPPA. And by the way, in closing of my first remarks here, none of the underlying cases have been held or proven by any court to have been frivolous. Thank you.
Mr. Gardella is going to argue for
Good afternoon, Your Honors. Andrew Gardella with Martin Tate Martin Marston here on behalf of the appellees. Judge Stafford, in the prior arguments, you were curious about the question about whether the first prong of the TPPA would require a showing of evidence. And it's our position, Your Honor, that I don't think so. I think the complaint, or in this case the amended complaint, bears out what the conduct is that's at issue that is being challenged under the TPPA. Under the statutory framework of the TPPA, which governs the procedure, I think Rockwell was the case that said we're not operating under Rule 12, we're operating under the procedural gambit of the TPPA. It spells out in 2017-104 what the procedure is, and a respondent can put forward affidavit evidence, but it's the plaintiff, or it's the petitioner's burden to make out a prima facie case that the conduct at issue, which is being complained of, falls within the gambit of protected activity. And so in our instance, we have alleged certain conduct that I'll talk about in that amended complaint. And from our standpoint, that is the framework from which the petitioner then bears the burden to lay out a prima facie case. I suppose there are instances where, I suppose the petitioner could put forward evidence to lay out that prima facie case, but I think if that were to happen, that would start to upend some of the general principles of the TPPA, because there's a general stay of discovery under the TPPA, and in effect what would happen is that their submission of evidence would result in our submission of evidence and could necessarily incur further discovery that the TPPA doesn't really contemplate because it's seeking an expedited resolution to these matters. So I think, Your Honor.
Well, I'll explain to you the reason I asked the question. The trial court, in its order, somewhere in the order makes the statement, he discusses the holding in Youngkin and notes that fraudulent conduct by an attorney may be actionable. And I draw the distinction between simple malpractice, simple negligence, a missed statute, or fraud. And I'm trying to figure out how the trial court made that jump to fraudulent conduct.
Well, fraudulent conduct, I believe the trial court was pulling out of the cases from either Texas or California in the discussion of the litigation privilege, which was never raised below.
So the trial court was not focusing on this case then?
I believe this trial court was referencing law from the other jurisdictions, okay, Your Honor.
All right.
That's my recollection of the opinion.
Y'all know a lot more about this case than we do at this juncture, but we will know.
Certainly.
I'm just trying to sort out where the trial court was in its analysis and reasoning.
Right, and I think the trial court was rightfully looking at the law that Mr. Parra asked the court to look to in support of their position. It just turns out that when the court looked at that law, it determined that when looking at the actual allegations of this lawsuit, it didn't comport with the allegations of the other lawsuits where the TPPA applied, particularly Youngkin, with non-parties bring claims because of what was alleged. And I think that kind of hits the nail right on the head as to where we really need to start, because I think it will address some of the questions Your Honor has about, the evidence or the allegations where Judge Davies is getting this from, and where he created what he believes to be an exception, not under the TPPA. He didn't engraft an exception under the TPPA. He looked at the facts and applied it to the TPPA to determine that it doesn't apply here. So I think it's the allegations of the complaint, and that brings me to looking squarely at the complaint, because throughout the briefings, throughout the proceedings below and on argument, there's this repeated effort to characterize our action as being basically an effort to vindicate the many, many years of litigation and to sue because we were the prevailing parties and punish the Mitchells and basically bring claims because these lawsuits, these successive serial lawsuits were filed dating back to '04. But if you look at our first amended complaint record, volume 2, 219, 220, 222, this sets forth the factual predicate for the allegation. The allegation is tort of another. That's the claim for relief. That's from Pullman Standard, 1985 case, Tennessee Supreme Court. Not a novel theory whatsoever. This case has been in existence since '85. The law is very clear. The facts of this case fit squarely within the law. That there has not been cases that have emanated from courts or the appellate court levels that detail these exact facts is a difference without a distinction, to be honest, Your Honor. I mean, it really doesn't matter. It fits right in the law. But what are the torts? Because that's what this is about. This is about the commission of torts by the Mitchells in their representation of Mr. Cartwright, who is another. They committed torts of malpractice, malfeasance, concealment, breach of fiduciary duty, tort against another, their client, Mr. Cartwright, which caused our clients to be ensnared in 15 years of litigation, incur all sorts of fees and costs, lost time, the dissipation of the trust assets, and the incursion of attorney's fees. Starting at paragraph 69, we lay out over successive pages, bullet point after bullet point after bullet point, what these torts are. And I think it's very important because when you look at these allegations, it's going to dovetail right into the statutory language of the TPPA and demonstrate that this is outside the context of what the TPPA would allow protection for. The first bullet point, the Mitchells failed or neglected to disclose actual results of the various lawsuits that they filed on Mr. Cartwright's behalf. When I go through the statute in a minute here, Your Honors, I'm going to point out that the TPPA requires a communication. That is within the definition of what the exercise of the right to petition is. We are alleging failure to communicate. The failure to communicate is not within the auspices of the TPPA. And there is case law to that effect dealing with language that is exactly or almost exactly identical to the TPPA in Texas. The case is Snell v. Ellis, 2021 Westlaw 1248276, Texas Court of Appeals, April 5th, 2001. Another case, Ray v. Fikes, F-I-K-E-S, 2019 Westlaw 6606170, Texas Court of Appeals, December 5th, 2019. Each of those cases squarely stand for the proposition, although it's in the context of a legal malpractice case, that the failure to act did not insulate the allegations that the lawyer failed to act, that the lawyer did not speak, did not communicate, did not allow that lawyer to take protection under the TPPA because it wasn't a communication. So that's our first allegation. Next allegation, Mitchells failed or neglected to communicate with Alan Cartwright. They didn't tell him about the nature of the suits, the risks of the suits, the damages that he could incur. The next allegation, the Mitchells persuaded Mr. Cartwright through false pretense to continue to pursue these suits. How did they do that? They employed threats. He asked to end the cases. They said, you're going to be on the hook for hundreds of thousands of dollars. They created in the next page, they created a relationship that was conflicted by interest. They did not tell him to seek out independent counsel to consider what they were doing. All of these things In that spectrum of conduct, while it may have been something of a method of communication, it didn't further the interests of the TPPA, and specifically the definitional understanding of what constitutes the right to petition. The right to petition first must fall within the protection of the United States or the Tennessee Constitution. And it must also intend to encourage consideration or review of an issue by a federal, state, local, legislative, executive, judicial, or other government body. Telling your client that you're going to be on the hook for hundreds of thousands of dollars if you end the lawsuit is not furthering anything for a court to consider. In fact, we allege that that type of conduct was furthering the interests of the Mitchells personally to the detriment and to the exclusion of their own client. Again, that fails the necessary definitional standard that a petition and the exercise of the petition has to be conduct that's encouraged, is intended to encourage consideration or review by a court. None of that is intended to do that end. There's more and more allegations in paragraph 69 going through record 221. But in there, you'll see, as I said, either two categories of allegations of wrongdoing and tort. The failure to communicate, the concealment, the misrepresentation, or on the other hand, the active subversion of Mr. Client's interest in favor of the Mitchells. In either event, there's either a failure to communicate, which takes us out of the TPPA, or the communication is not in furtherance of a judicial proceeding. So I think that might help to answer, Your Honor, Judge Stafford's question about do we need evidence. Your Honor, I think you have everything you need as to whether this can satisfy the first prong of the TPPA, because the allegations in this lawsuit squarely take it out of that.
Let me ask you, why do you say the failure to communicate takes it out of the TPPA? And all of the things you just outlined to us are actually part of Mr. Cartwright's claim against the law firm. I mean, you don't get the benefit of that, actually, as I see it, in your lawsuit against them. And it seems to me that the TPA that says that you have a right to file an action, and as the Texas court found, that the law firm is entitled to protection under the anti-SLAPP statute in Texas if it's a non-client, which is the case here.
In Texas, the difference, Your Honor, was that the Youngkin attorney was making the attorney was Youngkin. He walked into court and announced under Texas's Rule 11 that a settlement had been reached, and he read it into the record. That is a communication made during the course of a judicial proceeding and furtherance of that proceeding. That is significantly different than the allegations in paragraph 69 that I just went through in this complaint regarding the tortious conduct of the Mitchells and their representation of Mr. Cartwright. They're not announcing anything in the court. They are either not telling Mr. Cartwright something, or what they're telling Mr. Cartwright is not in furtherance of the resolving a legal right before a court, but rather, as we've alleged, in furtherance of their own self-interests. So that's what the distinguishing feature is that there is no communication. And to answer your question, Your Honor, the issue about communication and its import comes straight out of the TPPA. It's 2017-105. The petitioning party has the burden to make a prima facie case that a legal action against the petitioning party is based on, relates to, and in response to that party's exercise of the right to petition. And the exercise of the right to petition is defined as a communication that falls within the protection of the United States Constitution and is intended to encourage consideration or review of an issue by a court. Youngkin was communicating to the court, asking that court to consider something in furtherance of a legal right. Communication requires the making or submitting of a document or statement under the Tennessee PPPA.
Okay, what about the statements in a legal action that are filed, like in this case, the legal actions that the Cartwright filed against the Garners? Is that not a communication?
In his legal malpractice action,
In the actions that they filed on behalf of him against the Garners.
well, it is a communication, but that's not what we're suing them for, Your Honor. The tort of another, the torts that we're suing for are the tortious conduct that that the Mitchells in their representation of Mr. Cartwright engaged in, as set forth in paragraph 69. The result of all that is that lawsuits were filed, which is in turn the basis of our damages under the Pullman Standard case. But we're not suing Mr. Cartwright's counsel because lawsuits were filed. What we're suing for is under the tort of another, that they committed torts which resulted in harm to us as well as Mr. Cartwright. He's bringing his own claim for that. We're bringing our claim for the damages we incurred as a result of those torts.
And you don't think the statute has any application at all, you know, given the facts here? We're talking about a non-client suing an attorney who filed an action on behalf of a client.
Under the fact,
Even though perhaps without merit.
under the facts that are alleged in this complaint, Your Honor, I think it has to be a case-by-case analysis. I do not think this satisfies the definitional standard of the exercise of the right to petition, because it is not a communication. The conduct for which we are seeking recovery for is outside the gambit of a communication, because it involves concealment, or to the extent it did involve a communication, it was not in furtherance of a judicial proceeding. It was to damage, well, it resulted in damage to Mr. Cartwright and our clients, and it was for the benefit of the Mitchells singularly. So I do not think that this case, under these facts alleged, falls under the auspices of the TPPA. Youngkin was very, very different because it simply involved an attorney standing up in court, exercising the right to petition without any sort of suggestion that he was acting against the interest of his own clients.
You would agree, though, that filing an action is petitioning?
I think that is a correct statement, Your Honor,
Okay.
so long as it meets all the definitional standards of exercise of petition.
Thank you.
All right, thank you, Your Honors.
Members of the court, we're back to the definition. And again, at the risk of repeating myself, I mean, the statute itself, the operative language of Section 20-17-104 triggers the TPPA if a legal action, meaning this one, is filed in response to a party's exercise of the right of free speech, the right to petition, et cetera. And then, as the court has heard, exercise of the right to petition is defined in Section 103 as a communication that falls within the protection of the either Constitution and is intended to encourage consideration or review of an issue by a state judicial body. The trial court was not, whatever mistakes it made, it was not under any illusions about what this lawsuit is about, nor should this court be. And the trial court along the way, it said several things about that, both out loud in the transcript, but also in its order. It says, the Garners, quote, in this lawsuit are seeking to recover damages against defendants for depletion and waste of the family trust's assets and attorney's fees and costs and expenses incurred by the trusts in defending against various lawsuits. Now, Your Honor, I have the greatest respect for counsel for plaintiffs, but the contortions that you've seen in their briefs, in their pleadings, and even here in the last few minutes to try to suggest that somehow all they're suing about is, I guess, private conversations between my clients and their client, and somehow those don't have anything whatsoever to do. Don't look over here at the lawsuit. I mean, even being as charitable as conceivably possible, even if counterfactually, my clients were not counsel of record. Let's say they didn't file the lawsuit, some other lawyer did. Well, the very statements that were just described here, which, by the way, we contest factually, but set that aside for now, we're not there. telling the client, keep pursuing these lawsuits, because if you don't, you're going to have terrible liability. Is that, let me see here, intended to encourage consideration or review of an issue by a state judicial body? It's not, we're told. I don't know how to process that. I don't understand that, and even remotely. I think it's very clear that the court, where the court pressed, didn't have any trouble understanding what this lawsuit was about. This lawsuit was about, quote, 15 years of litigation. That's what it was about, hence the epic problems with the statute of limitations. And also, yes, it is a novel theory. Frankly, I respect the notion that there are two cases that go back some years on this, but it is in fact a novel theory to be used for this purpose of busting wide open the American rule. And the contortions to try to separate out those allegations, I think, are ones this court can't indulge in. I just don't see how they make any sense for this court to rely on. And I guess in closing, I come back to where I began, which is I'm reminded of a case from quite some time ago where this very court, in this courtroom, faced a similar issue of looking at the law, looking at the statute, where a party was arguing that for an exception to the law, specifically the Tennessee Public Records Act. It was the 1990 case of Creative Restaurants versus City of Memphis. And the city said, well, those documents that the commercial appeal wanted, if we give those up, they were subleases for tenants of bars on Beale Street. The city, you may know, owns Beale Street, the street, or the property. And the city said, oh my gosh, judges, if you let the Public Records Act apply to tenant subleases, we will be in a terrible disadvantage as far as economically renting that space out. And Judge Tomlin wrote for the court, and Judge Tomlin ruled in our favor, and Judge Tomlin ruled that there was no exception. And along the way, he said, perhaps it can be said that some type of confidentiality should be developed for governmental entities seeking to promote a project such as this. The writer has noted in the past that the Tennessee Open Records Act needs fine-tuning in certain respects. The writer also recognizes, however, that Mr. Goodwrench is the General Assembly, not the Court of Appeals. Well, members of the court, as to both of these cases, if the plaintiffs want the law to be as they say it is, they need to go back to the legislature, which only in 2019 enacted this law, and the language just doesn't support their position here. Thank you, members of the court.
Thank you, counsel. We will take these matters under advisement. We will attempt to get you an opinion at the earliest possible time. We appreciate your argument. I appreciate your briefs. We'll be in recess till the call of the docket in the morning.
All rise. This honorable court stands adjourned.